Good morning, my name's Kate Selway. I'm joined by my colleague Matt Mills. Matt was called in 2016. He has a very busy broad chancery practice, and slightly scarily, he also manages to fit in being a lecturer in land law at Oxford. So Matt, definitely someone who knows his easement from his elbow. Ha ha ha. The subject of our talk this morning is also a convenient excuse while the numbers continue to grow to share a funny legacy story before we get going. Over the years, I've come across a few gems, like the man who expressed a wish to be buried in a coffin made of cardboard, transported in a white van, stressing that no one except the driver of the white van should attend his funeral. I think that was perhaps the bizarrest clause in a will I've seen. But I do like this one I spotted the other day. It's from Heinrich Heine, who was an early 19th century German poet and literary critic, which all sounds rather highfalutin. He said in his will, apparently, "I bequeath my entire estate to my wife on the condition that she marries again. That will ensure there will be at least one man who will regret my death." Anyway, that rather tickled me. You haven't heard that before, Matt, have you?
No.
All right, well, look, joke's over for now, although I'm sure we'll think of a few more as we go along. I'm going to hand over to Matt now for the first part of our session. Matt, over to you.
Thanks, Kate. Well, good morning, everyone. And like any self-respecting millennial, I'm going to fall back on the secondary school IT level crutch of a PowerPoint presentation. I'll set out the key principles before asking Kate to share her pearls of practical wisdom on this topic. And the question we'll consider first is, how can you bring a claim against an estate which doesn't have a personal representative? Well, the starting point, as you all know, is relatively straightforward. Pretty much any claim that you can bring against a defendant can be brought against their estate. That's Section 1 of the 1934 Act. However, there are three important exceptions to this that I should mention. The first is on the screen at the end of that quote. As the statute confirms, defamation claims can't be brought against the defaming party's estate. Secondly, though, obligations which are personal to the defendant can't be enforced against their estate either. For example, if I contract to create some artwork, that can't be enforced against my executors who might have no idea how to draw or paint. For the record, neither do I. Thirdly, claims based on purely joint liability, not joint and several, can't be brought against the estate of the deceased if there are other surviving jointly liable people. Obviously, the key feature of joint liability is the doctrine of survivorship, which is basically last man standing, except in this case, last man standing takes the full liability. So if your case falls into any of these three situations, don't go charging ahead into what I'm about to talk about, because there might be nothing for your client to enforce. All right, in the normal course of events, someone will take a grant of probate and you can simply write to them, set out your client's case and go from there. But what if nobody comes forward to take a grant of probate? Or what if someone's named in the will and they're refusing or delaying? Well, in my view, you've got four main options here open to your clients. The first is your client could apply as a creditor for letters of administration and then recover their debt through their administration of the estate. The second option would be to bring a claim against the estate of the deceased defendant and issue an application to appoint someone to represent the estate in that claim. The third option is issuing a citation to require the named person to take a grant of probate or not. And the fourth thing you can do is threaten a personal claim against these personal representatives who are failing to pay the debts at all or with reasonable diligence. So I'll say a bit about each of these four options. If you can't find anyone who could represent the defendant's estate, then you might need to take matters into your own hands. Rules 20E and 22(3) of the non-contentious probate rules confirm that a creditor can apply for a grant of probate whether or not the deceased left a will. That type of claim is brought pursuant to Section 116 of the Senior Courts Act. Now, it doesn't matter whether your client's debt's from a contract or a deed. It doesn't matter how much or how little it's worth. All your client needs to do is prove that it's a creditor in some form. And if your client secures a grant of probate as creditor, they can take the cost of that application out of the estate. And if the estate's solvent, they can pay all of the debts, including their own. That sounds ideal. What's wrong with that? Well, there are four caveats you should bear in mind here. The first is that to obtain a grant of probate for a creditor, they must show why those with a higher priority in rules 20 and 22 are not applying. That's called clearing off. And in practice, what that means is showing that the other people have renounced or been cited and refused to take a grant. That adds a little bit more work to the process of enforcing your client's debt. Second thing to bear in mind is your client cannot attain a grant of probate as creditor if they purchased the debt after the deceased died. It's only the OG, the people who were original creditors before the death, that can apply. Thirdly, obviously, if your client takes a grant of probate, they then become a personal representative, and that subjects them to various important duties in the administration of the estate. They can't simply grab their cash and run. Fourth point is be careful if your client has a claim for damages rather than a simple debt claim. Although personal representatives have a statutory power to compromise claims against the estate, a beneficiary may fairly complain if you simply automatically pay yourself in full for the value of a potential, say, negligence claim. In those circumstances, in my view, it's probably safest to apply to court for confirmation that the claim is good and can be paid in full. Now, that type of application can be issued without naming defendants and can be dealt with on the papers, so it doesn't need to be particularly onerous. But in my view, it's important not to rush ahead if there is this potential conflict. The second option is to bring the claim against the estate of the defendant and apply for an order appointing someone to represent the estate for that piece of litigation. This is all in Rule 19.8(2)(b) of the CPR. Now, this is usually the most convenient approach. But again, there are four important points to bear in mind. The first is that an application to appoint a representative for the litigation must be made before the period for service of the claim form expires. So you can't dilly-dally here, you've got to make sure you act promptly. Secondly, until someone's appointed, the claim is effectively stayed. So your client shouldn't go rushing ahead with default judgment or disclosure or evidence because that's all probably going to be void. Thirdly, the court will likely direct your client to give notice to anyone who's got an interest in the estate or an interest in the claim. For example, co-creditors, co-defendants, or potential beneficiaries of the estate. And those people will be allowed to have their say. Fourthly, the court's unlikely to appoint someone to represent the estate against their will. So if you're putting someone forward as a potential representative, make sure you've contacted them in advance and sought their written consent. If you're stuck for ideas of who to ask, my view is that you should sensibly start by asking the close friends and family of the deceased. Alternatively, you could ask perhaps previous solicitors who've represented the defendant in similar litigation or the transaction, or even contact the official receiver if you can't, official solicitor if you can't contact anyone else. And when you approach these people, in my view, it's worth reminding them that if you are appointed under 19.8, this does not make you a full personal representative. This does not subject you to the full range of duties as executor or administrator. It's only this specific task that the representative has. So that can give people some comfort if they're worried about incurring wide-ranging personal liabilities. But what if the deceased died leaving a will, but the named executors are simply refusing to obtain a grant? Or they've got a grant, but they're delaying in progressing your client's claim? Well, in those situations, you can consider taking steps targeted at the personal representative themselves. I'll start with a gentler option. You can't sue a named executor in negligence for failing to take out a grant of probate, but you can issue a citation. This is your third option. Rule 47 of the non-contentious probate rules allows a creditor to issue a citation requiring the named executor to accept or refuse a grant. And if the named executor doesn't appear, then their rights end and the right to administer the estate automatically goes down the chain of priority in Rule 20 or 21 of the non-contentious probate rules. But even if the executor does appear, if they don't apply for a grant with reasonable diligence, then your client creditor can issue a summons essentially for a grant in their own name. So we're back to option one again. But in my view, there's three things to bear in mind for this type of application. First is that this type of citation can be issued at any point. That's different for a citation against someone who's intermeddled, which can only be brought 6 months after death. So don't confuse the two. The second and third points are both practical. And the second one is, this would obviously be a further legal, procedural cost and time and expense to add to your claim and to add to the process of recovering the debt. So you want to make sure the client's aware that this isn't going to be a quick job overnight. And the final point to bear in mind is that if the personal representative you're chasing is just likely to be rubbish, even if they are appointed, if they're just likely to carry on delaying, it might be better to apply to court under section 116 of the Senior Courts Act to simply pass over them and try and cut them out of the picture entirely. The fourth and final option applies if the deceased defendant had a personal representative or someone's intermeddled, but they're unduly delaying in progressing your client's claim. In that situation, you can remind the personal representative that they may be personally liable for their failings here. The key case is, of course, Reed Tankard, in which Mr. Justice Uthwat confirmed that personal representatives must pay the deceased debts with due diligence. Now, in simple cases, in practice, that means paying within a year, unless there are good reasons not to. And this has been sometimes used to good effect. For example, personal representatives have been held personally liable for not paying debts before the estate was distributed, or for failing to pay an interest-bearing loan quickly enough so the interest accrued and caused loss to the beneficiaries. Now, it's important to remember here, these types of claims can be brought by both beneficiaries and creditors. So sending an ominous letter to the personal representatives, reminding them of their potential personal liability here, can be a powerful tool to kickstart them into the administration of the estate. But there are two important caveats here. Firstly, this is likely to be a bit of a nuclear option, particularly if you do issue a claim. And that could jeopardize any amicable relationship between the parties, particularly if, as in cases I've had, the claimant creditor is friends with the person who's the PR. The second practical point is, if your client is claiming a joint debt, then make sure you join all of the relevant jointly owed or jointly owing parties to any particular claim. So those are your main options as far as I see it for suing an estate which doesn't have personal representatives. We'd welcome any questions from you, so please do drop them in the Q&A box at the bottom of your screen. But to get the ball rolling, I thought I'd bring in our star act, Kate. When it comes to the rock and roll world of private client law, Kate is very much the headline act performing at Wembley, and I'm very much the support act down your local pub, asking for a pint in return for a song. Kate's been practicing in private client law for the best part of 2.5 decades, and now comes fully equipped with a silky gown and full-bottomed wig. Her practice covers all manner of tax and private client matters, including failed tax avoidance schemes involving gilt-edged securities, whatever that might be. Maybe Kate can enlighten us, but I'm sure she's got lots of things that she can help us with here on the issue of suing an estate. So I'll stop sharing and say, Kate, have you ever been instructed by a creditor to chase a debt against the estate?
Yes, I think in many times and in many circumstances, but perhaps most consistently, when I was on the Attorney General's B panel, I used to get a lot of instructions from HMRC, who, as you can imagine, were and are often creditors of estates. And these used to be particularly problematical because the level of debt was usually such that no family member wanted to take out a grant. I had a spate where there were huge sort of CGT liabilities or income tax liabilities, and spouses or family members were very worried that if they started administering this estate, it was likely to be insolvent because the revenue had been chasing for its money. So in those particular cases, what tended to be the most appropriate thing to do? HMRC sort of wanted to know the variety of remedies, the citation remedy that you've been through, the discretionary grant remedy under section 116. And sometimes we adopted those courses of action. But in fact, often, because the level of debt was so high, the revenue preferred the insolvency administration order route. And that's something I'll be talking a little bit about later in the case study. I mean, it is a bit of a nuclear option, but the revenue really, in those sorts of cases, that was the most sensible thing to do.
That's perfect timing, Kate. We've just received a question that says, how would your approach on the 4 options differ if it's alleged the estate's likely to be insolvent? Well, that's exactly what Kate's going to talk about in about 5 or 10 minutes. So we'll come back to that and you'll get the full silk treatment on that answer there. You won't need to hear from humble old me. Shall we go back to the second part of my talk then, if there are no further questions? Fantastic. Well, we're back to our old friend PowerPoint, but I promise this time our trip down IT class memory lane will be a little bit briefer. So far, Kate and I have been discussing what you can do if a proposed defendant dies before your client can issue a claim. But what happens if your claim's already underway when the defendant dies? Well, in my view, once again, your client has four main options. The first is to ask the court to substitute any personal representative of the estate as a defendant. The second is to apply to the court and ask it to proceed in the absence of anyone representing the estate. The third option is to apply for a grant of probate as creditor. And the fourth is to go through the citation process I discussed. Now, obviously, you'll see that options C and D are what I've discussed earlier. So I'm going to use my Year 8 IT skills and focus on the two things that I've highlighted on the screen. So option 1. As Williams, Mortimer and Sunnox put it, where a party to an action that's on foot dies, but the cause of action survives, now that's what I talked about right at the very start, the action does not abate, and where the interest or liability of that party devolves upon some other person, the court may substitute that person as a party. And that's reflected in our procedural rules. Rule 19.24a allows the court to substitute someone if the existing party's liability has passed to a new party. Fortunately here, you don't need to worry too much about limitation, because if the limitation period expired after the claim was issued, but before the defendant died, Rule 19.53c of the CPR confirms this is one of those exceptional situations where substitution is allowed, even though limitation has expired. So in practice, if an executor or an administrator is appointed after the deceased died, then you should hopefully be able to agree a consent order, file it at court, get it sealed pretty quickly, and get things moving again relatively quickly. But unfortunately, that's not always possible. So your second option here could be to apply to court to proceed in the absence of anyone representing the estate. And that's possible under Rule 19.81a. Now, importantly, as it says on the screen, if the court proceeds with this route, the judgment will still bind the estate. It will still bind any personal representatives who are later appointed. So don't worry about your client being prejudiced by this option. However, unsurprisingly, in practice, courts very rarely award an order like this, which allows a claim to be proceeded against an estate when no one is representing it at all. In fact, I looked at all 50 reported judgments on Westlaw that cite Rule 19.8 and could only find 4 examples. Now, unfortunately, there's no real guidance here, so I'll just give you the examples and you can use them hopefully in any analogous cases. In the first case, the beneficiaries of the estate consented to the claim proceeding without anyone representing the estate. Now, that wasn't decided, but it was argued, and in my view, it's a very good argument, because if the only people who could potentially lose out are consenting, that could hopefully push the court in the right direction. In a second case, the defendant's wife was going to be both the executor and main beneficiary of the estate. She was already the second defendant to the claim, so the court thought there's no need to appoint someone to represent the estate, because essentially the person who has all of the interest in the estate is already part of the claim. In a third example, the estate was a respondent to an application for permission to appeal, which was pretty hopeless. And at the end of what I think was an ex tempore judgment, the judge said that because the application had failed, the estate should take the benefit of that failure and made an order to ensure that the estate would be bound by that judgment and therefore could take the benefit. In the final example, the defendant died after the trial had been concluded, but before a reserved judgment had been handed down. And unsurprisingly, the judge made the order so that the judgment would then be binding on the estate and wouldn't have to go through the whole process again. As I said, options C and D are things we've discussed before, the citation process and applying for a grant as creditor. So that brings me to the end of my PowerPoint frolic. Again, I'd be very happy to take any questions from the floor, but to kick things off, I'll throw it back to Kate again. Kate, have you had many cases where someone's died during litigation and it's caused problems?
Not many. I mean, it's not something that obviously, fortunately, crops up particularly regularly. But in the few 2 or 3, 4 over the years cases I have had, it's never been a straightforward thing to solve. You'd think that you might be able to get over this hurdle relatively quickly, but for example, what has tended to happen in most of them is where the death has been sudden or unexpected. That defendant's personal representative, it takes people a while to decide, for example, whether they even want to be executors, whether they want to act. And there's this dilemma, therefore, for the claimant who wants to keep the show on the road, and the court that wants to make sensible case management directions. And there's a tension between whether you should join that person's named personal representative to represent the estate, or whether you should choose another. So I think the struggle to get someone to represent the case is often simply played out in delay. I think you can obviously eventually get to the end of it, and it does involve probably the claimant being proactive, which can of course be super insensitive as well, but the claimant needs to get on. So ultimately, in all the cases that I've been involved with where that's happened, the main issue has actually been delay. It never seems to have happened particularly quickly that we've got the thing back on track.
Thank you. Should we turn now to the question that was raised to us about insolvency? Segue nicely into your talk.
Yes, let me just have a quick look at that question again. How would the approach on the 4 options differ if it's alleged that the estate is likely to be insolvent? What I'll discuss now in my case study that I've called Fred and Mabel, names changed to protect the innocent, and my case study will be available for you afterwards as a short written paper. But where a state is likely to be insolvent, there are specific rules that one has to follow if you're a personal representative. And I won't answer that question in detail now. The short answer is yes, it probably does differ. And what you need to be thinking about from the outset, I think, is the insolvency administration order route. My written paper goes into more detail about that. But I think hopefully the question can be answered by me telling you about Fred and Mabel, my case study for today, over the next 15 minutes or so. This was a case I had, as I said, names changed a couple of years ago. I've decomplicated it slightly because there's simply too much to burden you with this morning. But Fred and Mabel were an elderly married couple with no children. Their only surviving relatives were a couple of nephews of Mabel's in their 30s. Fred died in November 2018. Mabel died soon afterwards in February 2019. And there had been questions about Mabel's capacity for quite some time. And you'll see as we go on that this case study does involve a rather large number of problems. So between them, Fred and Mabel owned substantial assets, their London house, £1.5 million or so, and then a £1 million investment portfolio. Now, they were jointly owned, so they passed by survivorship to Mabel on Fred's death. And Fred, in fact, owned little of value in his sole name, a car and about £50,000 in various bank accounts. Mabel, who inherited all the joint survivorship assets in her surviving few months, also owned some valuable artworks that the nephews had long had their eyes on, and jewellery, together worth about £250,000. Now, in their later years, Fred and Mabel had taken out an equity release mortgage on their London home to finance their living expenses, and the sum owed to the lender at the date of Mabel's death was about £750,000. And some added complications in relation to Fred's estate and its liabilities were twofold. Fred and Mabel had a housekeeper who was employed by Fred, and in the last year of his life, Fred fired her summarily for alleged theft, and she brought a claim for unfair dismissal, which was compromised by Fred agreeing to pay her £20,000, but he hadn't done so at the date of his death. And Fred and Mabel also used a chauffeur regularly. And after Fred's death, the chauffeur claimed that he had been an employee and that Fred hadn't been properly contributing to his pension. So he intimated a potential claim against Fred's estate. The merits of that were always pretty unclear. And an added complication was that, and here we're talking about parties and who you might join as parties and who are the right parties for things. Fred and Mabel were also the trustees of a registered charitable trust that had been a will trust established under the will of Mabel's late father, whose objects, we needn't go into the details, but broadly speaking, they were for the relief of poverty. Now, problematically, in the last few years, Fred and Mabel had borrowed £50,000 from the charity's assets to help them pay the wages of the chauffeur and the housekeeper. So the problem we had at Fred's death was that joint survivorship assets passed to Mabel. Fred only had assets of about £50,000 to £70,000, but he had liabilities amounting to at least £150,000. Settlement sum to the housekeeper, solicitors' fees that had been wrapped up in that employment claim. He had some medical fees, he had credit cards, he had a small CGT liability. And then there was this potential claim from the chauffeur, which was an unknown liability. So let's pause there and think about Fred and Mabel's wills now. Fred made a will leaving everything to Mabel, naming an old business friend, Mr. Smith, as his executor. And if Mabel predeceased him, Fred left his estate to the foundation, which obviously didn't occur, but it's relevant because Fred hated the nephews. Mabel, on the other hand, she'd made 2 relevant wills. In her penultimate will, made in 2014, she'd left her estate to Fred, but if he predeceased, as he did, then to her 2 nephews. In her final will, made in August 2018, which had been prepared by solicitors but executed at home, she left her estate to Fred, but if he predeceased her, then her jewellery and artworks to the nephews, but the residue to the charitable foundation. And in both wills, she named an old accountant friend, Mr. Jones, as her executor. So the problem you had at Mabel's death was that the nephews were convinced that her last will was invalid because they were convinced she'd lost capacity by that date, and they put in a caveat. The beneficiaries under the prior will was the charitable foundation, but the charitable foundation had lost both its trustees because that was Fred and Mabel. So you had a charitable foundation that had no representation at all. So Mabel's estate, she'd inherited everything from Fred, so her estate was fine, enough to pay off her liabilities. But the problem was obviously a series of problems. Let's sort of itemize them and go through them. Fred's solely owned property amounted only about 70,000. His jointly owned property passed to Mabel. Too many liabilities in his estate to be satisfied out of the 70,000 that was left. So his estate is technically insolvent. How are his debts to be paid? What should Mr. Smith do, who's the executor? He's a loyal old friend with a strong sense of responsibility, but should he take out a grant or should he renounce? If he doesn't do anything, who's going to do it? So that was his dilemma. Meanwhile, some of Fred's creditors, particularly the employee, the housekeeper, wanted her 20k, and the solicitors who acted in that case for Fred, they wanted payment of their fees. They were clamouring at Mr. Smith for payment of their fees. Now, he hadn't even decided yet whether he was going to take out a grant or not. Let's turn to the charitable foundation. Fred and Mabel are dead. Who's going to represent the interests of the foundation? It's owed at least £50,000 because of the borrowings. It's also the residuary beneficiary of Mabel's last will, which the executors wish to challenge. So which will should Mr. Jones seek to admit to probate? He saw Mabel a few months before her death and thought, well, she's bright and alert, I think she's fine. But the nephews had compelling evidence of cognitive decline from personal experience of when they saw, they're convinced she had Alzheimer's. So while Mr. Jones is pondering what to do, the nephews enter a caveat. And Mr. Jones wonders how he can move on the situation, given that there's no one representing the charity who might be able to negotiate the probate dispute with the nephews. Now, what happened then was that Mr. Smith did decide to take out a grant, believing that to be the right thing to do. And that wasn't difficult in that there was no IHT to pay. So he could get clearance from HMRC pretty quickly. But he instructed solicitors to advise him on the apparent insolvency of Fred's estate. and signed the usual retainer agreement, agreeing to be liable for the firm's fees. So alarm bells ringing there. If you're an executor, what do you do if an estate's insolvent, appears to be insolvent? Do you wade in with both feet? And here he is signing a retainer when there's no fees to pay, with which no money with which to pay administration expenses, and he's agreeing to be liable for the firm's fees. And as I said, he's got these creditors pressing. In fact, not altogether wisely, Mr. Smith decided to pay those creditors, those two creditors, off to get them off his back. Not the right thing to do at all in terms of how a potentially insolvent estate is supposed to be dealt with, either outside formal bankruptcy or using the process of the insolvency administration order, or possibly even applying to court under Part 64 for directions. Poor old Mr. Smith, without even telling the solicitors, took matters into his own hands and simply used the assets to pay off two creditors. Now, one of the nephews, let's go back to the nephews, one of the nephews was pretty proactive and was concerned in Mabel's estate about the accruing liabilities on the equity release mortgage. So he went and took out an ad collegenda grant, a limited grant, simply giving him the right to sell the house and pay off the equity release mortgage. And that actually occurred pretty quickly. And what this prompted Mr. Smith to do, on the advice of his solicitors, is to say, and here we get into insolvency territory, is, and this is, I've explained this in greater detail in my written paper, is to use what's called the clawback remedy under section 421A of the Insolvency Act. And that is a provision that if you go for an insolvency administration order, the trustee can then, specifically in relation to formerly jointly held assets that pass from Fred to Mabel, can apply against Mabel's estate to claw back such assets as are necessary to enable all the liabilities in Fred's estate to be paid. And so what Mr. Smith and his solicitors said to the nephew, who was represented, is, right, we've got this remedy. Okay, it's a two-stage process. We'd have to get an insolvency administration order first, but we've got this remedy we can use. It's going to be very costly and expensive to do that, but obviously it will work. So why don't you make life far easier by simply, out of the proceeds of sale of Mabel's house, give us some assets so that we can settle Fred's liabilities. That will save us all having to use our formal remedy. Nephew agreed, quite surprisingly, I think, and all Fred's liabilities were paid off, with the exception of these administration expenses that Mr. Smith had run up instructing the solicitors. And those got to more than 50,000. And then the nephew suddenly got cold feet. So he said, oh dear, what have I done? What should I have done? What shouldn't I have done? And he's now unsure, first of all, whether under the terms of the limited grant, he actually had the necessary authority to pay off any of Fred's liabilities from Mabel's estate under the limited grant. After all, you know, he hadn't sought, there's this potential probate claim, and he hadn't sought the permission of the court. He hadn't contacted the charity, which of course lacked trustees, so there was no one to contact. They just simply agreed. So he was suddenly worried, and given the dispute over Mabel's will, you know, there was no one for him to go to at the foundation. So he believes he may have been too hasty. He also, more importantly, turned around and said to Mr. Smith, those fees you incurred, what business did you have doing that? The estate's insolvent. You presumably signed a retainer with your solicitors. You should be paying those yourself. To which Mr. Smith's answer was, oh no, you know, quite rightly, if I've got a section 421 remedy, or the trustee has, you know, those fees would be covered. And I think that would have been right, but it was obviously quite a risk that Mr. Smith took. So how, in those circumstances, would you seek to move the situation forward? We've got a number of problems, haven't we? First of all, well, I'm not necessarily in this order, but how would you deal with the fact that the trustee, the charity has no trustees? appoint new trustees. Who's entitled to exercise that power under Section 36 of the Trustee Act 1925? Well, it would be the PRs of the last surviving trustee. Mabel's PR, Mr. Jones. What did he do? He didn't want to do it himself, and he couldn't find anyone who might be willing to act as a trustee. Could you contact number two? Could you contact the Charity Commission? That is one possibility. The Charity Commission has power to appoint new trustees under Section 82 of the Charities Act 2011. In this case, Mr. Jones wrote to the Charity Commission, but they didn't reply. Third option, which is what occurred in this particular case, is contact the Attorney General as at the Government Legal Department, at the GLD. Attorney General, you'll all know, is the protector of charities and charitable interests. And the AG could then take a view on the merits of the nephew's intended probate claim and could choose either to defend or compromise it. So the AG would have power to do that, and could also take a view on the potential clawback remedy proposed by Mr. Smith. So in that case, that was the route that was followed. So that logjam was eased by the AG becoming involved. Something I go into detail, more detail in my written paper, is the Section 421A remedy. Now, there's a really interesting technical point in relation to that remedy that hasn't been litigated yet. I'm quite keen to litigate it, but I don't suppose it comes up much in practice. And the wording, that's a remedy exercisable against the survivor's estate. But the wording of that section, without dragging you through the detail now, suggests, and there's also a comment in Muir-Hunter which seems to back this up, that the survivor, Mabel, in this case, actually has to be alive when the insolvency administration order is made. Now, that seems to me to be a bit bonkers if that were the actual requirement, because the mere accident of the timing of the survivor's death, I think, would impact very arbitrarily and very unfairly on the creditor. After all, the purpose of this section is to assist a creditor in clawing back assets to ensure that debts are paid. So it's a fascinating little wrinkle, but it's a point that the nephew who'd taken out the grant, it's a point that his solicitors spotted in Muir-Hunter to say, anyway, why would it be so easy for you to exercise this 421A remedy? This is what Muir-Hunter said. Mabel's already dead. Bad luck. So that was a difficulty in this case. Let me wrap up very briefly by following that technical point by just suggesting how it was resolved at a mediation, I'm glad to say, but there is an alternative to the insolvency administration route, I think, provided the parties were willing to recognise that in theory it could potentially be exercised. And that's if all parties, in this case, the AG needed to be involved as well as the nephews, and of course, both sets of PRs. If all parties are represented and in agreement that a remedy under Section 421A was at least a possibility, then what you could have done to sort out the insolvency in Fred's estate was simply agree a deed of variation involving a retrospective severance of the joint tenancy. So more assets stayed in Fred's estate retrospectively. Alternatively, Mabel's beneficiaries, the rival beneficiaries under both wills, could simply agree that Fred's liabilities should be satisfied from Mabel's estate as a consideration for Fred's executors refraining from bringing those 421A proceedings. So just let me turn back to the question that was asked earlier on. I think if an estate is likely to be insolvent, my top tips are the executor needs to be extremely careful before, and think very carefully about it before deciding whether or not to take out the grant and get into that whole difficult business of incurring expenses when the estate's likely to be insolvent. There might be this onward remedy that was potentially available in this case under section 421A. But in some cases, executors might reasonably think, well, why should I bother? And that's the dilemma that HMRC had in a number of those cases I mentioned earlier on. And what my written paper does, it emphasises the three key things you've got to think about if your estate is likely to be insolvent. Which way are you going to proceed? Are you going to proceed under as if, informally, but as if it was going to be administered in bankruptcy? That's what something called the Deceased Persons Order, a statutory instrument from 1986, specifies. Are you going to ask the court for directions, which may be appropriate, or are you going to go down the insolvency administration route? Hopefully any additional questions might be answered in my paper, but if anyone's got any questions now, do pop them into the chat box. I'm aware I've overrun by a couple of minutes. Matt, did you have any observations on all that?
I just wondered if the deed of variation route was chosen, would the parties need to consider any tax consequences?
They might do, of course. They might do, of course. I think in this case, in this particular case, they didn't, for reasons that are probably a little complex to go into. But you will have remembered in this scenario, on one scenario, it goes to the charitable foundation, so no IHT. On one scenario, Mabel's estate goes to the nephews. Obviously, inheritance tax would therefore definitely have been payable in Mabel's estate. So it was a source of lots of mathematical calculations as to the precise amount they were going to settle at. But of course, in general terms, one would always advise to explore the tax position carefully before entering into any deed of variation. Right, well, I think, Matt, that about wraps up our double act. I think it wraps up the entire two-day conference as well. So on behalf of all at Radcliffe Chambers, Matt, myself, and all the other speakers that you've listened to, both in Chambers and our external speakers, I do hope you've enjoyed our programme. That's great. Thank you all very much, and we will say goodbye, and we hope to see you soon. Goodbye.
Thank you. Goodbye.